Firstly, I would like to explain the introduction. According to Act 303 of the Islamic Family Law Federal Territories Act 1984 in Section 2, the interpretation for illegitimate child is a child born out of wedlock and is not a child from Shubha intercourse. Next, similarly, the 44th Muzakarah Fatwa Committee (MKI) on June 1998 detailed the definition of an illegitimate children, stating, "An illegitimate child is child out of wedlock, either due to adultery or rape, and he is not from the Shubha intercourse or a child from slavery." Next, a children born less than 6 months and 2 years by Qamariya calendars from the date of Tamkin, which is intercourse. According to the Mufti of Federal Territories, an illegitimate child is a child born more than 6 Qamariya months from the date a married couple is solemnized in an illegitimate child. Hence, according to the above hadith, an illegitimate child is linked to his mother and is not be linked to his biological father, according to the opinion of the majority of scholars from the 4 mazhab. This matter is also clearly stated by the Muzakarah of National Fatwa. Illegitimate child is impermissible to be linked to the man which caused his birth or anyone who claims to be the father of the child. Hence, he may not inherit from one another and will not be a mahram and may not be the wali.
According to Section 110 of the Islamic Family Law Federal Territories Act 1984 defines, where a child is born to a woman who is married to a man more than 6 Qamariya months from the date of the marriage or within 4 Qamariya years after dissolution of the marriage, either by the death of the man or by divorce, the woman not having remarried, the nasab or paternity of the child is established in the man, but the man may, by way of li'an or imprecation, disavow or disclaim the child before the court. Section 111 of the Islamic Family Law Federal Territories Act 1984 defines, where the child is born more than 4 Qamariya years after the dissolution of the marriage, either by the death of the man or by divorce, the paternity of the child shall not be established in the man unless he or any of his heirs asserts that the child is his issues. Next, Section 112 of the Islamic Family Law Federal Territories Act 1984 defines, if after iddah the woman did not remarry but gave birth within 4 years, then the legitimacy of the child shall be subscribed to the previous husband. Hence, in Section 113 of the Islamic Family Law Federal Territories Act 1984 defines, where a man has shubhah, sexual intercourse with a woman, and she is subsequently delivered of a child between the period of 6 Qamariya months to 4 Qamariya years after the intercourse, the paternity of the child shall be ascribed to the man.
Thank you, Farahim, for the clear explanation. I am Shafika and I will present the issue of Anak tak sah. In our country, there are a lot of issues concerning illegitimate child. Hence, two of the issue will be discussed in this topic. Firstly, the issue regarding to court declaration to the illegitimate child. Based on the case of WNHA versus MHI 2018, the fact that the plaintiff, who is WNHA, filed a child legitimation application for her son named MEH bin MHI. The child was born 2 months after the plaintiff's marriage with MHI, who is the defendant as a father. The issue arises concerning the topic is whether the child was a legitimate child. Based on the plaintiff's testimony, she was pregnant 7 months during the akad. At the same time, defendant knows concerning to the plaintiff's pregnancy and they decided to get married. Held that the court cannot convict the lineage of the child as a legitimate child of the defendant because it does not comply with the requirements of Islamic law. Based on Section 2 of Islamic Family Law of Selangor State 2003, defined illegitimate child as a child born out of wedlock and not from shubha intercourse. Another one, based on Fatwa of Selangor State, illegitimate child defined as a child born less than 6 months, which is 2 lahzah according to lunar calendar, from the date of tamkin cannot be bequeathed to the man who conceived the woman. Hence, by referring WNHA versus MHR 2018 case, we have agreed with the decision of the court as a careful method of judgment is well made, such as by referring the enactment of Islamic family law Selangor State and the decisions of the Fatwa Committee. Moreover, the court tests the evidence regarding the case by using few methods, such as bayinah and ikrar. There are several approaches to addressing the issue of illegitimate childbirth. First and foremost, adultery rules and penalties should be enhanced, such as raising the amount of lashes and fines to encourage individuals to avoid sex without marriage, which impacts lesser of illegitimate delivery. Next, the crucial part that needs to be emphasized is awareness of an illegitimate child's life, which will include concerns such as marriage and validation in his or her offspring. This is done so that people are aware and compassionate, and as a result, sex outside of marriage is avoided. To sum up, sympathy and awareness are vital in life since they are the key to prevention. As an example, awareness and sympathy regarding the issue of anak tak sah might discourage sex without marriage and result lowering the percentage of children born out of wedlock. The second issue is the difficulty in confirming the child's paternity in order to claim for maintenance of the child. Based on the case of Nurzaini binti Alias versus Muhammad Sharif bin Muhammad Taib 2006, the fact that the plaintiff and the defendant were married on April 10, 1987 and divorced on August 21, 1989, and the date of the childbirth was on February 27, 1988. The plaintiff, who is mother of the child, claimed for her child's maintenance after the child attained the age of 13 due to her desire as a mother to see her child succeed in life like others. Then, the defendant, who is the child's father, refused to pay his child's maintenance because he only knew of the existence of the child when he received the summons from the plaintiff claiming for fasakh, held that their marriage is for 9 months more according to the year, and if calculated accordingly to the lunar month, the period of 9 months is more than the minimum period of pregnancy, which is for 6 lunar months. That period took into account the possibility that the plaintiff contained the proceeds of intercourse on the first night. The court is therefore of the view that the conditions for a child born by the plaintiff to be passed on to the defendant have been met in this case. Hence, based on Section 73, Clause 1A of Islamic Family Law Negeri 9, 1983, the court ordered the defendant to pay to the plaintiff RM200 per month for child support and refused to repay the arrears of his child support. By referring the case of Nurzaini binti Alias versus Muhammad Sharif bin Muhammad Taib 2006, we are agree with the court's decision since it is based on a comprehensive technique of judging. For example, by referring to the enactments of Islamic family law in Negeri 9 and the Fatwa Committee's finding. Following that, there are a few tips to improve the issues, such as in marriage, we need effective communication so that all conflicts may indeed be solved. The decision of the mother in the previous case, which she not disclosed to his husband that she was pregnant, puts doubt on the child's lineage and results the issues of li'an arises. Moreover, in our point of view, a husband must be responsible of his child's needs as stated in Hukum Syara. In a nutshell, crucial part to be parents are the commitment in terms of financial ability, times of spent with family members, and trust to each other. When all that completed, any issue arises in the family could be settled easier as every party could discuss well and able to bear financially and so on.
So I would like to give you 2 example case. First, a child and anak against Jabatan Pendaftaran Negara NORS. The case summary. On October 24, 2009, the second and third appellants, both Muslim, were married. The first appellant was born 6 months after the second and third appellants married. Following the second and third appellant's application, the second appellant's name was entered in the register as the father of the first appellant in accordance with Section 13 of the Birth and Death Registration Act 1957, the Act. The issue arose when the second and third appellant discovered that the first appellant birth certificate stated that his father was Abdullah and not the second appellant. In this regard, the second appellant filed an application under Section 27, Clause 3 of the Act to correct the first appellant's surname from Abdullah to his name in the register due to an error of fact or substance. The court refused to allow a Malay Muslim illegitimate child to bear his biological father's name on his birth certificate. The child was born less than 6 months after the appellant's marriage. In my opinion, I agree with the court judgment because the child is born less than 6 months.
In the case of Muhammad Faizul bin Zainal and Suhaila binti Yusuf, the issue in this case is whether the paternity of an illegitimate child could be ascribed to the father in accordance with Islamic law. The facts of this case is the court was asked to determine the legitimacy of the plaintiff and defendant's child, as well as to ascribe paternity to the plaintiff. The plaintiff and defendant were married at the time of the application. Their wedding took place on January 8, 2009. The parties admitted to having an affair previous to their marriage, and as a result, the defendant became pregnant in August 2008. They also alleged that they waited a long time to solemnize the marriage because of an accident involving the plaintiff. They were lawfully married on January 8, 2009, and the defendant was 4 months into her pregnancy at the time. Hence, the issue began when the National Registration Department declined to include the child's father's name on the birth certificate. The refusal was based on the fact that their kid was born fewer than 6 months after their marriage was solemnized, which was inadequate to ascribe fatherhood to the plaintiff under Islamic law. Instead, the National Registration Department added the name Abdullah to the end of the daughter's name, making it Binti Abdullah. As a result, the plaintiff and defendant have filed an application to determine the paternity of the child and to have the court order that the infant be named after the father by placing his name after the Binti. The court held that the plaintiff's application to ascribe paternity to the child is dismissing. We are agreed with the decision of the court since the question that has been disputed in the case are resolved based on the holy verses of the Quran and text of fiqh.
Next example case is the case Faizal bin Rabi'an against Nurul Fazila binti Nawi 2014. This case summary, the plaintiff and defendant were married and the defendant gave birth to a child 5 months and 9 days after their wedding. The child, however, was not associated with the plaintiff as the father and the father's details on the child's birth certificate were listed as unknown. In the current claim, the plaintiff requested that the child be associated with him as the father and that the details of the child's father in the birth certificate be changed to the plaintiff's personal details. The plaintiff also requested that the National Registration Department register the child and issue an identification card with the child's name and the plaintiff's name as his legitimate father. Despite being aware that the child's paternity could not be granted to him under the Hukum Syara because the former was born less than 6 months from his solemnization date to the defendant, the plaintiff's claim was for administrative and legal reasons. Held that the claim was granted by the court and the reason is for administrative law or legal purpose. In other words, paternity should be granted for matters unrelated to Hukum Syara administration. In my opinion, I support this court decision. Next is the suggestion to improve this situation. First and foremost, keep the faith and strengthen the foundation of religious knowledge. This is the very important thing. Next, marriage. Marriage is required to enjoy such a natural gift and reap the rewards that come with it. This means that in addition, its other advantages, physical intimacy in marriage is rewarding. A fornicator or adulterer is someone who insists on having it illegally. Every religion forbids sex outside of marriage and punishes those who engage in it. Sex outside of legal marriage is a significant offense in Islam with numerous ramifications. Lastly, for those who had committed fornication before, rest assured that the doors of repentance are always open, no matter how great the sin is. Allah subhanahu wa ta'ala is the most gracious and the most forgiving.
Next, in the case of Muhammad Arif bin Ali and Siti Nur Aslinah Lim Limin, the issue in this case is whether the applicant who said to breach the consent judgment on child custody after the divorce could be issued show cause notice by way of committal proceedings. The facts of this case is, in 2009, the applicant and respondent married and had 2 children together. The first child was not legitimate, but the second child was legitimate. In 2014, the couple split and the court granted a custody order without the consent judgment for the children. The respondent allegedly violated the consent judgment's execution by failing to comply with it, according to the applicant. The respondent was accused of failing to provide the applicant custody of the first kid and denying him access to the second. The applicant sought permission to serve a show cause notice on the respondent and to carry out the order through committal procedures under Section 151, Clause 1, Clause B and Clause AA of the Sharia Court Civil Procedure, State of Selangor Enactment 2003. Therefore, the court dismisses the applicant's application. We are agreed with the decision of the court as the case has been carefully studied based on the provisions stated in the law. The suggestion to improve the issue of anak taksa from continuing to occur in our society is by empowering religious knowledge in a practical form to fortify oneself from being trapped by immorality and wickedness. The next suggestion to improve the issue of anak taksa from continuing to occur in our society is by making a strict legislation in controlling independent activities such as the ban on leaving the house beyond the set time, especially for teenagers. This is to prevent free association among them, which will lead to the issue of illegitimate children.
Assalamualaikum warahmatullahi wabarakatuh. I am Nur Alia Izzati binti Hamizi and I will talk about the conclusion. To conclude, anak taksa taraf is a very important issue that all of us must take note and give attention at. This is because the issue of anak taksa taraf can lead to many problems if this issue does not get enough attention. For example, if the issue of anak taksa taraf being neglected, there will be have issue of marriage between real siblings since they didn't have the knowledge about their real parents or siblings and thought that they are the only child. Also, it will lead to a serious case, which is there will be human beings who was born as a result of sexual intercourse from men and women who are in fact our siblings. It is true that this illegitimate child is the result of the couple's mistake, but do not add to the mistake by letting the welfare of the illegitimate child be neglected. In Islam, there is not a single verse of the Quran that explains that society should punish these illegitimate children. In fact, it is the duty of family members and society to protect and appreciate them. Thank you.